What do you do when you're caught red-handed with a smoking gun in an elevator with your competitor dead with a hole in his skull? That's right. You say, I need a lawyer. My name is Andrei Mincov. I'm the founder of Trademark Factory. And in this video, I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's about KFC caught using somebody else's trademark, Smoky Mountain. And here's what they did to respond. All right, let me start by reading from the article, and then I'll provide my comments. All right, KFC hits back at lawsuit, claims Boise Pizza Company fraudulently obtained trademarks. Hey, Colonel Sanders is biting back. KFC, the company formerly known as Kentucky Fried Chicken, denies it stole the name and logo of a Boise-based pizza company. And it claims Smoky Mountain Pizzeria Grill fraudulently obtained trademarks that form the basis of a dispute between the two companies. Last month, Triple T Enterprises, Smoky Mountain's Boise-based owner, sued KFC in the U.S. District Court in Boise, Idaho. It says KFC infringed on Smoky Mountain's name and logo after developing a Smoky Mountain line of barbecue chicken. The defendants are using the same word mark and a confusingly similar variation of the Triple T Smoky Mountain logo that incorporates both the term Smoky Mountain as well as Triple T's three mountain ridges into KFC's logo mark. A word mark is a registration of a company name or product without regard to font, style, design, or graphic features. It gives the owner flexibility to create different styles to illustrate the name. Yeah, so with word marks, you file them usually with all capital letters, means what you're protecting is the name, right? Regardless of the font, regardless of the color, regardless of the placement, whether it's all horizontal line, whether some of them vertical, whether you have two on top of two, regardless of relative sizes between the words, regardless of anything, right? You could this way go after anybody regardless of how they're using the same or similar name. All right. Smoky Mountain, which reported sales exceeding $30 million over the past 3 years, was founded in Ketchum in 1992. Today, it operates 2 restaurants in Boise and 1 each in Meridian, Eagle, Kuna, Nampa, Mountain Home, and Ketchum. In an answer filed Friday, KFC denies it did anything wrong. It also filed a countersuit that accuses Smoky Mountain of fraudulently obtaining trademarks for the company name, its three-peak logo, and other uses. KFC, which operates 4,333 restaurants in the United States, including 15 in Idaho, says the term Smoky Mountain is well known in the South to describe the Great Smoky Mountains in Tennessee and North Carolina. It's also a common term for a type of barbecue and barbecue sauce popular in the South. KFC claims Triple T Enterprises, in its filings with the U.S. Patent and Trademark Office, said the term Smoky Mountain had no particular significance, despite the Great Smoky Mountains and Idaho Smoky Mountains, a mountain range outside Ketchum and Sun Valley. Okay, so we're gonna get back to this in a moment, but this is very interesting. I've never really seen a defense like this, and this is, like I said, one of those cases when if you're caught red-handed, you need great lawyers to come up with an argument that, at least on its face, is viable enough to keep the fight going. All right, so an online history of Smoky Mountain included in KFC filing says the Ketchum location is where Smoky Mountain got its name. The statement was made with knowledge of its falsity and with the intent to deceive the Patent and Trademark Office and cause it to issue the registration, which it did. Boise attorney Newell Squires, who represents KFC, wrote in a 26-page answer. KFC asked the court to throw out Smoky Mountain's claim against it and to order the Patent and Trademarks Office to cancel Smoky Mountain's trademarks. Because the plaintiffs' registrations were obtained fraudulently, they cannot form the basis of a claim for infringement, Squires wrote in, arguing for dismissal. Churgi, Smoky Mountain's attorney, did not immediately reply for a request to comment. KFC said it began using Smoky Mountain to describe its line of chicken in 2017. The company said Smoky Mountain Pizzeria never contacted KFC to complain about the issue, about the use, or asking it to cause use or the term before filing its lawsuit on December 30th. Smoky Mountain also sued Grubhub and Postmates, two food delivery services. They're accused of delivering Smoky Mountain branded chicken from KFC to customers. Grubhub denied doing anything wrong as well. Its answer was contained in KFC's filing, and Postmates has not yet responded to the complaint. So a bunch of lessons here, a bunch of good lessons, and actually I'm going to reverse it, go from the end to the beginning. So first of all, why did the Boise, Idaho restaurant also sue the delivery services? Well, there's two reasons. You put pressure on more people, you put more pressure on more businesses that are related to the main target of your complaint, the more likely it is that they will want to settle. The more likely it is that they would want to come up with some sort of resolution to get out of this, because the more companies are suffering, the more companies are wasting money on lawyers, the more reasonable they want to become at figuring out the out-of-court solution. Also, the assumption is if they're right, then there's more opportunities to get more money as an award because of that. So that's why when you file a lawsuit, you look for every possible defendant you can throw in there and see what sticks. So that's the first thing. The second thing is KFC's claim that they never warned us, they just sued us right away, they never demanded anything. You're not required to send demand letters. You're not required to send cease and desist letters. You can just sue them right away. And as one of my good lawyer friends says, people who want to sue, sue. People who want to threaten litigation, threaten litigation, right? That's why oftentimes when you just receive a demand letter, you do nothing and you wait and see. It's kind of a game of chicken, right? You see, are they really going to sue you if you do nothing? Now, to go back to the main issue here is whether the Boise, Idaho's restaurant, the Smoky Mountain, falsified their response, whether the trademark application is fraudulent, and if it was, why does it matter? So, first of all, once the trademark registers, you have the presumption of ownership and validity. Especially after 5 years in, the application, the registration becomes incontestable. Nobody can go out there and claim that you shouldn't have gotten this trademark registered because on the basis of descriptiveness or on the basis of confusing similarity with a prior mark. And that limits your ability to do something with that trademark. However, if you can prove that the trademark was obtained by fraud, then you can attack that trademark. But fraud is an extremely, extremely high standard. It requires a lot more than certain small minor inconsistencies. And so there was an office action issued by the examining attorney. Once the Smoky Mountain filed their trademark, they asked them a question: does Smoky Mountain mean anything? Is there special significance to that outside of it identifying your product and services? And they said no. All it does is it identifies our business, and that's the whole purpose, right? We're not saying that we make things from Smoky Mountain. It doesn't mean that any food made in Smoky Mountain has any specific features, any specific characteristics. So no, they say all it does is simply identify us. That's why they entered that disclaimer in the trademark application that KFC caught on to and are trying to say they actually lied. They lied, they fraudulently said that in order to obtain registration. I don't really think this argument is gonna fly for two reasons. Like I said, fraudulent intentions are very hard to prove. And there's a very high bar of what you need to prove for it to be considered fraud. Fraud on USPTO. First of all, if you say something without fully understanding what it means, it's not fraud, right? You have to have intent to defraud the USPTO. And it's really a convoluted question. Does it have any significance outside of it identifying the company, the products and services? I don't know, probably not. And that's why I think it would be very difficult to prove that. But also, it could be true. It could be true because it's not that the question is, does Smoky Mountain mean anything in general? The question is whether Smoky Mountain means anything for this trademark, and that's a very different thing. So, for example, I'm going to just give you another example. Let's say Apple, right? Apple with their phones. Does the word Apple have any significance outside of identifying their phones? No, because their phones are not made from apples. They're not made to look like apples. They're not made to taste like apples, right? They don't have anything to do with apples. But does the word Apple have significance? Yes, but not in connection with Apple's phones or services. So in this case, I really don't think that KFC would be able to prove fraudulent intent. And if they can't prove fraudulent intent, then they would have to defend the case of trademark infringement. Again, there was no need for Smoky Mountain to prove to send any demand letters, and they have a registered trademark which creates presumption of ownership and validity. If KFC can't rebut that presumption, if they can't kill the trademark registration, then it will be very difficult for them to have a viable defense. But their lawyers are doing exactly what they have to do. They find ways to make viable arguments why they didn't infringe. They come up with arguments that will not be thrown out of court like this. And what that means is that because they have more money, higher legal budgets, then they can keep this thing going on and on and on until they find a way to settle on conditions that favor them rather than the other side. But hey, $30 million that the Boise restaurant makes is quite a chunk of change anyway. So they probably also do have a budget set aside to deal with this. So that one could be very interesting. That one could be very interesting one to follow. Quite honestly, I don't think it's going to go to full trial, but who knows? It's one that we're going to follow and see what happens with it. If you're interested, make sure you subscribe, get notified whenever the next video goes live. If we have an update, I'll shoot another video. Either way, like this video, post a comment below, let me know what you think. And if you got a brand that you want to protect, make sure you go to trademarkfactory.com, book a call with our strategy advisors, and we'll get your trademarking process started risk-free with a 100% money-back guarantee for a single flat fee. Guaranteed result for a guaranteed budget. It makes sense, right? And until then, I will see you in the next video.